number 97, People versus Lance Rodriguez.
Good afternoon. May it please the court. Hannah Khan of Appellate Advocates on behalf of Lance Rodriguez. May I reserve 2 minutes for rebuttal?
You may.
When police pull over a moving bicyclist on a public road, that's a seizure because
Says who?
Bicyclists reasonably believe, just like motorists do, when they're on the road, that a police officer's direction to stop is a command that must
Scooter?
be complied with. Absolutely.
So
When it's-
it would be a bike and scooter rule?
It would be any machine that makes you go faster on the
Hoverboard?
road.
Skateboards are not machines. Is that count?
I think it applies to any type of vehicle that, the VTL tells us has to obey the same rules of the road as cars. So bikes, inline skates, scooters, motorcycles, all of those are vehicles that raise inherent danger on the roads and that the legislature has recognized need to follow rules of the road. Bicyclists are told that they have to follow the rules of the road when they're on roadways. So the legislature has carved out special rules for the road because roads are dangerous. And there's a societal expectation that when you're operating something on the road that is dangerous, you comply when the police tell you to stop. Because any other rule would create unsound public policy.
So anytime a bicyclist is violating a traffic rule, you could pull them over, though?
On the road, absolutely, yes. If they have probable cause for a VTL violation, you could pull them over just like you could a car.
So if this case had involved the police stopping this particular bicyclist because of something that he was doing that violated a VTL provision, it would be a completely different analysis in terms of the stop and the seizure, arguably, and whether there was, a valid legal reason to do that.
Yeah, well, it would still be a seizure, but it would have been a
But it would have been based
legal
on a
seizure.
violation of the VTL,
Correct, but there was no violation of the VTL here.
alleged.
Alleged,
Yeah.
right. And Officer Schell only followed my client for 30 to 60 seconds. So arguably, if he had been a little more patient and followed unobtrusively, he probably would have gotten to a seizure. Mr. Rodriguez might have violated any myriad of VTL violations, or he would have better observed him to get reasonable suspicion for a crime. But Officer Schell stopped him prematurely.
So if he had turned the corner and taken out his gun and shot somebody, then the police could stop him. But short of that, they couldn't. Seeing the bulge, seeing him drive erratically was not enough for the police to pull him over and say, hey, what's going on?
Well, actually, I think there's a lot that goes between a bulge and actually shooting someone. I think there's a lot of things that could have been observed in between. Again, followed him unobtrusively, probably would have gotten a VTL violation, or could have, seen more, right? And if he doesn't get there, if there isn't reasonable suspicion of a crime and there isn't probable cause of a VTL violation, then it's hard to conceive of why, the Fourth Amendment protection should be disregarded and an immediate seizure needs to happen. And I think that critically, the critical test here is, would a reasonable person feel free to leave? Did they stop because police action told them that they had no choice but to stop?
Didn't they ask him to stop once and he didn't? And there were 2 requests to stop, weren't there, in this case?
Yes, one followed right after the other, and
Does the first refusal or disregard of the request or command to stop teach us something about what the state of mind of the defendant was in terms of his ability to not comply?
No, I don't think so. This was very quick, and also it's not what my client believed, it's what a reasonable person would believe. But anyway, I think that the fact that there was a repeated command shows that, Officer Schell was treating this like he would a car stop. He commanded him, police, hold up, and when my client...
Does it matter that there were no lights or sirens?
No, absolutely not. Just like for cars. You know, if someone can pull over a car without lights or sirens, that's still a seizure. I think what Officer Shell
Is it
did...
any less intrusive without lights or sirens?
No, and again, you know, the idea of intrusiveness and shows of authority
Didn't
and
they
anxiety-
identify themselves as officers?
Absolutely. He said twice, police, hold up, and then police, hold up. And you know, after the first police hold up, when my client continued, he didn't say to himself, well, he's free to go, that's his prerogative, this is only a level 2. No, of course not. He treated this like a car stop. He pulled him over. Police, stop, you know?
So would you look at the facts and circumstances of this case to determine the level, or would you say any time a person's riding a bicycle and you're asked to stop, that's a level 3?
I would say anytime a person is moving a bicycle on a public road, on a roadway, and that police tell them to stop, that is a seizure, because you have both an obligation to stop.
So tell them, command them, or ask them, please, to stop? Does it matter how they ask, or automatically, once you request to stop, it's a level 3?
I think that if you request to stop, just like with a car or a motorcycle or anything else that's driving on the road and subject to VTL obligations, there's a societal expectation when police say, please stop, that you will stop.
So your operative factor is driving upon the roadway.
Yes, I think
So
that
if
is key.
he'd been riding his bicycle on the sidewalk, is it a different standard?
Yeah, I'm not advocating for a rule that applies to pedestrian areas. I'm advocating for a rule where when bicyclists are acting like cars, when they're on the roads and they have to follow the same rules as cars, then they are seized just like cars.
Suppose he'd been, facts are all the same, except Mr. Rodriguez is walking down the street, and the officer tells him to stop. Does he have a right to just walk away?
Yes, if he's on a sidewalk, under the people's analysis of this, if this was a request, then yeah, he could keep
I
walking.
thought the question was, what if he's walking in the middle of the road? I may have
No, I was actually
misunderstood.
walking on the sidewalk.
Sidewalk,
Walking on
right.
the sidewalk.
Yeah, I think the rules for pedestrians are different, and again, it might very well be a seizure. You look at all the circumstances, you look at the tone and the authority involved, and I think certainly here, you know, Officer Schell's tone was very authoritative. This wasn't a request, there wasn't a question mark at the end of, you know, police, hold up. This was a command. Officer Schell acknowledged it was a
But
command.
now I think
So
you're
I'll
going
ask that
back.
question. What if he's walking in the road?
What if,
Not on the curb, not on the street,
so
which is a pedestrian pathway. So what if he's not doing that?
So if pedestrians are generally not allowed to walk on the roads unless there's no sidewalk, and even so, they're not allowed in the middle of the road, they have to be on the left, so I think you'd have probable cause for a VTL violation there. But I do think
And
that,
so that means if the officer tells him to stop, and he kept walking, what happens?
he would have to stop. That's a seizure.
Well, what happens? Could the officer
Oh, and
then
he kept
arrest him?
walking?
If he keeps walking?
Yeah, I mean, I think the officer could affect a seizure, absolutely. There's probable cause of a VTL violation. But I think that the key here is that we can't have bicyclists.
So the bicyclist on the roadway is told to stop, and let's say the officer observed a VTL violation. If the bicyclist doesn't stop, the officer can then try and forcibly stop him?
Yeah, absolutely. And I think any reasonable bicyclist would think that they would need to comply with that. We can't have
So
a
does
different
that
rule.
mean if there was a decision below that there was a VTL violation?
There
that
was
This would
no
be a
V-
whole different case?
I think if there was a fact that there was a VTL violation, then yeah, I think there would be
But didn't-
different grounds.
Maybe I've misunderstood this record. Didn't the court credit the officers that they had observed defendant bicycling recklessly?
Right, so there was no determination whether or not the recklessness actually was a VTL violation. And again, Officer Schell could have just followed him a little longer and determined whether he was actually violating the VTL or not. I see my time is up.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Mariana Zelig, Queens County District Attorney's Office, Office of Melinda Katz. Your Honors, initially, this is a mixed claim before the Court. Therefore, it's only subject to this Court's review if the record supports the Appellate Division's conclusion that this was a Level 2 stop under DeBoer.
Don't we have to know what the legal standard is?
Yes, Your Honor. The legal standard in this case, whether it was the correct application of the level of DeBoer in which the lower court, the suppression court, and the appellate division found, which was a level 2. In this particular case, the court said that it did not rise to a level of a seizure. The appellate division did not rise to a level of a seizure. And therefore, they felt there was a founded suspicion based upon this defendant riding his bike in a reckless manner with one hand on his waistband, holding a bulky
Counsel,
item.
it almost seems, the way I read the suppression court decision, and I'm not sure you're arguing this, it's unclear to me in the record, but there's almost an alternate finding by the suppression judge that there was justification for a level 3 seizure, when the judge says, moreover, since the officer had a reasonable suspicion that the defendant was engaged in criminal activity, the stop and brief detention was authorized. That's a level 3 justification to me for a stop.
Are you talking about the suppression court's decision,
Yes.
correct? Yes, Your Honor. The court did write that, but it was not quite clear because the tenure of the decision, you're correct, but the decision, the way it was written, it appears that the court felt that the reasonable suspicion was actually once the defendant said that he had a gun. That would be, I think, the correct way to interpret it because the substance of the decision was he initially had, the officer had the initial right to inquire when he saw the erratic bike riding, and then subsequent to that, once he
Clearly
saw
they
the
say
bulge.
that, but your view, and I agree with you, but your view
thank you.
then is that it's just inartfully phrased, but
I agree,
it's a level.
yes. That would be my.
So the only question here is founded suspicion, level 2
Correct.
intrusion.
Correct.
And whether
Which
this
is-
goes beyond that.
Correct, because reasonable inferences could differ. Reasonable minds could differ on the inferences that could be drawn.
You're arguing Bora Ocasio deference. to-
Correct, correct. But aside from that, Your Honors, based upon the facts of this case, it did not rise above a level 2. And in this particular case, if the court
Why
looks at...
didn't it rise above a level 2 when he keeps writing and he's told again, stop, police? That doesn't sound like an invitation at that point.
No, I wouldn't quite go to say it's an invitation, Your Honor, but what it is in this particular case is, under this court's jurisdiction in People v. Bora, for example, and even in the U.S. Supreme Court decisions, a stop, a command to stop, even a request, or even if it's classified as a stop, as a command, is not sufficient to constitute to a level of a seizure, and it would not indicate to a reasonable person that he was restrained, that his freedom of movement was restrained. Indeed, even a level 1 stop starts with a request to stop. A level 1 encounter, starts with a request to
So
stop.
what would elevate it?
If there was more indicia of force, or in other words, if the police car maybe had cut him off, and then with their guns drawn, and then their sirens went on, and their lights and sirens, and then the 3 officers that were present initially in the vehicle may have surrounded the defendant, that would clearly rise to the level of a
And what
seizure.
happens when the police say stop and someone doesn't? Let's say defendant did
Sure.
not. They kept going on the bike.
Sure.
Turned and kept going. Now what?
Without more, that would have been
Keep
it.
following, saying stop, stop, stop.
He could continue following, but that would be all the officer could do in this
And
particular
if at that
case.
point they cut in front of him, then you say,
Then I would say it would rise to a level of a
And
seizure.
suppose he'd been in a car, and the police come up with a megaphone and say, stop. Otherwise, everything's the same. Is that a level 2 or level 3?
Well, if, according to this court's jurisprudence, that would be a level 3 if the car was in motion, on the road.
So
And that-
then, isn't that really the question here, is should we have a different standard for a bicycle if otherwise the facts are the same?
Correct. So our position, Your Honor, is that the standard should not be the same for 2 reasons. The first reason is the intrusiveness of stopping a police car in transit, and the second reason is the visibility of a person on a bicycle. So
You can have visibility of certain motor vehicles. They're Jeeps. They have no roof, they have no doors, it's completely open. Is it still not a motor vehicle?
I think it would depend on the particular circumstances. You're correct. If it's convertible, that might rise to the level of indicia of criminality. Then possibly the police might see,
But that's probable cause.
yeah,
That's
that would
not-
rise
that's
to,
not
right,
a-
correct. That would rise to the level of probable cause. But in and of itself, a bike should not be compared to a car because it would also make it difficult for the police to carry out their general policing duties. If a car is riding on the sidewalk, then the police would have a right to stop that bicycle, 1, for a VTL violation, and 2, because they would also possibly have some other indicia that they would want to inquire under the 4 levels of
So
DeBoer.
are you saying if the bike is treated differently, despite it being in motion, despite, quite frankly, now they're electric bikes, bikes can travel at certain speeds, somehow the police are prevented from doing their law enforcement duties if you require more of them?
Well, if I understand your question, Your Honor, it's not they would be prevented, yes, because an officer, well, let's say in this particular case, sees the bulge or the bulky item in the defendant's waistband, for example. You wouldn't see that in a motorist, right? Because if the car is driving at a certain speed on a highway,
You might see it on a motorcycle, and so...
You might see it on a
And so where do we
motorcycle.
put motorcycles? With your bike rule or with the car rule?
that might be another case, Your Honor.
Well, it might be, but that's the problem with this case, is that we have all kinds of things on the road.
Correct.
And a line's going to have to be drawn somewhere.
Correct, and that's why the people
And so if the line is
position-
visibility, that doesn't help, that has a necessary implication for motorcycles.
Correct, but the issue is visibility and the intrusiveness. And that's,
Yeah, so the visibility, I have a little trouble along Judge Troutman's lines understanding. I mean, that would make it certainly easier for the police to detect something that would give them probable cause, but that doesn't really go to the intrusiveness of the stop, right? That's just what you can see. The intrusiveness seems to me to have more to do with the motion.
well, the issue, Your Honor, is that everything technically is a motion. A pedestrian is a motion. A scooter, as the court had said, a hoverboard, a unicycle.
Isn't the test, look, there's this car rule, but the real test is, would a reasonable person feel that this is a limitation on their ability to move, right? They've been
Correct.
seized. In a car, there really seems to be only one way you can get a moving car off a highway. You put your lights and flashes on, the trooper comes out of his car, he's got his hand on his holster, and he walks over to your window, right?
Right.
I think the case law that we have seems to me to say no reasonable person's is going to think, yeah, I could just keep going. You know, the lights and flashes are on, guy's following me, and it puts the siren on, but no thanks, I'll keep going. The question is, this is different, right? It's a bicycle, there's no lights and sirens. So are we going to essentially assume lights and sirens here in every case where someone asks a moving bicycle to pull over? Or are we going to look at all the facts and circumstances? That's what this case seems like
Correct.
to me, right?
That
So
is.
what is your reason why we should not apply the lights and sirens rule to a moving other vehicle?
Well, it's really the totality of the circumstances, as Your Honor said. And that's really the heart of the Fourth Amendment jurisprudence. We shouldn't be making bright-line rules, and this court has eschewed from making bright-line rules because it's not enforceable for police on the street to be able then to carry out their duties. By its very nature, a car stands apart. And Your Honor, as you had said with the motorcycle, that might be, I think, fact-specific.
A bike is required to follow the V&T.
Yes.
There are bike lanes now. They are integrated into our society such that there are many people that don't drive motor vehicles. They instead choose to operate bicycles and at, quite frankly, excessive speeds beyond what a car is traveling at oftentimes. But you're saying they're still not, they should not be treated any differently than walking on the street when they're actually within the flow of traffic.
Yes, Your Honor. Well, one, I don't believe bicycles that are pedaled by human power can go faster than a motor vehicle.
Have you not seen
Traffic,
traffic
they
with traffic?
And by the way, they don't listen.
No, but they
but they
go
don't
a lot faster, they go a lot faster, having ridden my share of them, than a human being. And they can actually go faster than someone who's running. So they actually have a great deal of
True.
speed, and if they hit you, they can cause tremendous injury.
That's true, but the reality is, Your Honor, it shouldn't rely only on the movement. It should be on the totality of the circumstances, because where do you draw a line? Now a police officer, if you impose the rule that a bicycle is now a car, where do you draw the line with a police officer? So now a bicycle is a car, but then do we come back here for a scooter? Do we come back here
Well, you're
for a
not arguing,
skateboard?
are you, Counselor, that you can never seize a bicyclist, that
Correct.
circumstances wouldn't amount to a seizure, right?
Correct. We're saying, look at the totality of the circumstances. There should not be a person, I'm sorry, Your
I
Honor.
thought the police prefer bright-line rules.
I'm sorry?
I thought the police prefer bright-line rules that make it easier to know in this category, we always can do this and we always can't do that, rather than, gee, I've got to make an on-the-spot decision. Isn't that harder?
Well, not really, Your Honor, because even within DeBoer, for example, it's confusing the difference between level 1 or level 2, and the same similarly situated facts could potentially have different results depending on the court that reviews it. But in terms of bright line rules, yes, we're saying in Fourth Amendment rules, it would be difficult for the police.
What about some of the amici briefs indicating the impact of being pulled over in certain communities? Does that matter?
Well, Your Honor, I don't think that the race rhetoric is relevant.
Rhetoric?
Well, in terms of the issue about race, in terms of black or brown communities or indigent communities, it should rely on the Fourth Amendment protections of the reasonableness of the police conduct in every particular situation and how the police respond.
Yeah, but then your rule, as I understand it, even though you eschew a bright line rule, is that the cops got to block them. The cops block them, you're done. That's a seizure.
Well, it
That
depends.
seems very aggressive, and I don't think we've ever
No,
said you
I-
need that full kind of intrusion.
I was about to say it has to depend on the totality of the
Okay, so
circumstances.
give me what's less. I mean, you have a car following, then the car is right next to them. You have the officer and the court both identifying the words spoken as commands, not invitations, not solicitations, not, would you please do this, sir? Commands. So
My time is up. May I
other than,
continue?
my point is, other than, since you say that's not enough under the circumstances, but if indeed they cut him off, that would be enough, where's the middle?
Well, Your Honor, it's very difficult to answer that because every situation is so fact-specific. But in this particular case, if I may, the words command, yell, pursuit, those were all words that were brought out by a very competent defense attorney on cross-examination. And if you look at the hearing minutes in total,
What step short of blocking them, if this is not enough, would elevate it to level 3?
in this particular case.
Yes, let's give a little
I would
guidance.
think-
What would it be?
Sure. I would think if the police tried to stop him with lights and sirens, or the police came with their guns drawn and said, freeze, hold it, don't move. Something like that would rise to a level of a seizure. But in this particular fact, there was just, and even if you want to phrase it as a command, it was just more
If
of
you don't
a
stop, I'll
statement.
arrest you. Does that one work?
That would work. If you don't stop, I'll
Because-
arrest you.
because?
Because the standard for a seizure is whether a reasonable person would feel there's a significant interruption of their liberty of movement. And clearly, if you don't stop and I'll arrest you, a reasonable person would feel then they can't move, their liberty is restrained. But even the United States
So
Supreme
why
Court...
wouldn't a reasonable person think, under these circumstances, late at night, on a road, cops have been following, cops is now parallel to me, commands and yells more than once, twice, we'll stay with the twice, that if I don't stop, I'll get arrested. Why is that not a reasonable
Because it's a-
conclusion by a reasonable person on that bike under those circumstances?
Well, it's actually a reasonable person innocent of wrongdoing, Your Honor, that's the standard. And in this particular case, if a police officer, any show of authority could be unsettling for an individual, but the issue is, do you feel free to go? And in this particular case, the police did not do anything that would indicate to this defendant objectively that he was not free to go. What if the police said, oh, excuse me, you dropped your wallet? I mean, it could be something as innocuous as that. It's no different than a pedestrian walking on the street and said, please stop. That was the case in People
Let me ask
versus
you this.
Bora.
If there was a history in that particular community of officers being particularly aggressive with men on bikes, would you say that might create a different situation? I'm not talking about race rhetoric, as you termed it, just data, just plain old data.
Well, Your Honor, I don't think I could answer that question to say if it was just based on data, because it wouldn't be specific to the facts of the particular case. I mean, there's
It's
good
known
cops
in
and
that,
bad
it's known
cops.
in that community that officers are aggressive for people who are on bikes, men who are on bikes, excuse me. It'll make a difference.
Would it make a difference if that was a seizure then? I don't understand the question exactly. Can you rephrase
Does
that?
that make a difference to the analysis as to whether or not a reasonable person under these circumstances would believe they're not free to move?
I do not think it would make a difference, Your Honor, because it's an objective standard and it's a reasonable person. And the standard, at least with this court's jurisprudence, is not specific to a community necessarily. It's specific to the reasonable person viewed objectively.
Thank you, counsel.
Thank you, Your Honors.
Counsel, language like the totality of the circumstances and weighing the governmental interest versus the intrusion into the subject's ability to move freely in the world is very comfortable for a lawyer. Maybe not so comfortable for a cop, but, that's the sort of language we work and trade in every day. So why is that not a more appealing option for deciding whether these kinds of encounters violate the person's rights, as opposed to some arbitrary rule about whether something is a motor vehicle or not a motor vehicle, or has momentum or doesn't have momentum? That doesn't seem to live in the real world to me, where everything really depends on where you are, what time it is, what the character of the neighborhood is, all different kinds of things. So just tell me, why is your rule better than her rule?
Okay, for two reasons. The first reason is, as this court said not that long ago in People v. Garcia, we need bright line rules because law enforcement have to have even application of these rules on the road. The rule we're proposing is a very workable rule. If something is on the road and the person operating that thing has to follow the same rules of the road as cars, then they are seized when they are told to stop because they have to stop. The second reason why this rule is necessary is because of what happened in this case. The appellate division applied a bright line rule. It was the wrong one. They said bicyclists are uniformly treated as pedestrians. That's not true, nor should it be. That would create a real safety problem on the roads. We are
But
putting...
hold on, if we're going to talk about safety and a police officer's duty to patrol, to investigate crimes, to keep order in society, if we're talking about safety, and you're asking us to say that it's completely unreasonable, I think, for a police officer who observes someone operating their bicycle in an unsafe manner, these are the facts below, right? These are the facts that we have, causing other cars to stop so they wouldn't injure him or injure themselves, holding on to a bulky item in his waistband, which we've ruled before is a telltale sign of a weapon. You're saying for safety reasons, that police officer can't say to that guy, hey, can you hold up a minute?
He can, and that's a seizure, and he needs reasonable suspicion to do it. We are putting bicyclists in an impossible situation if we do what the people are advocating. Is a bicyclist supposed to decide if an officer's request is just a request, if he can keep going? Is he then going to be charged with violating, the lawful order provision? This is not a workable rule for people on the roads.
But you're saying in this case, this didn't rise to the level of a seizure. So the facts as I've laid out, according to you, is not a seizure.
No, this was a seizure. He commanded him to stop, he pursued him, and my client importantly submitted to that authority. He had a show of authority, a pursuit, a repeated command.
But they
and
didn't have
authority was
reasonable
told.
suspicion.
They did not, and the people have never
So
argued that
so
they
what are
have.
we supposed to do in a public setting, in a community, if guns are prevalent and if guns become more prevalent? A police officer seeing a bulge can't stop someone and say, hey, do you have a license for what's in your waistband? You're saying that's not enough reasonable suspicion to sustain this seizure.
No, a bulge is not, nor have the people argued that it is. We're not asking this court to determine whether or not Officer Schell had reasonable suspicion. The people have never argued that. And the answer to your question is follow him a little longer. You followed him for 30 to 60 seconds. That was not enough time. Do good police work, and you will be rewarded with reasonable suspicion or probable cause of a VTL violation.
As I understand your argument, counsel, it's, the bicycle rule, or any alternative if we do not adopt that rule, that this was a level 3 on all the facts and circumstances, right?
Yes, absolutely. And lights and sirens aren't dispositive. In Wren, it was still a seizure even though we pulled a car over without lights and sirens. It's not about lights and sirens. It's about whether the person feels they have to stop. And bicyclists on the road feel like they have to stop, and we should want them to feel that way. And police should be able to have a workable rule. But whatever this court decides, whether it's because bicycles stops are always seizures, or whether it's because there was a clear command and a submission to that command in this case, this was an unlawful seizure. The people have never argued that there was reasonable suspicion, and so the evidence should be suppressed and the indictment dismissed.
Thank you, counsel.
Thank you.